Hello, this is Angela Jones, Registered Unlawful Detainer Assistant here at ldaprolegal.com, and today we're going to talk about when can you start the eviction process and how long it takes. So you can start the eviction process once the proper notice has been served and has expired and the tenants have not complied with that notice. And making sure that you don't give any extensions beyond the notice period is very much so required. So you don't give any more extensions, you don't renegotiate any new terms that can ruin the validity of the notice. So you just have to stand strong on that notice. And if in fact they do not comply, move forward with the eviction. The eviction process, all in all, it varies by county as to how long the process takes. Some counties are quicker than others. It can take anywhere from, on average, I would say, for the quicker counties, it could be like 2 months. That includes a sheriff lockout. For those counties to move a little bit slower, you're looking at about 4 months, and that's for an uncontested eviction all the way up to sheriff lockout. Of course, there is, variations of time depending on circumstances in the case, but that is the a lot of time that you should be expecting as a landlord in order to regain possession of your property. As far as the entire process itself, tenants will have so many days to file an answer in court after being served, depending on how they're served. If they don't file an answer, you can obtain a default judgment, which would include a writ of possession, and then that writ of possession is taken down to the sheriff's department, and the lockout is scheduled by the sheriff at that time. The agent meets the sheriff there, changes the locks, and moves forward with the eviction. If they file an answer, then a court hearing would be required, and utilizing our services, depending on if you are pro per or not, you would have the option of either representing yourself in court or hiring one of our cooperating attorneys to represent you in court. And then after the court hearing, the judge would make a final ruling, and then once you get your final judgment, you can proceed with the eviction. So as far as the lockout, I should say, for the sheriff lockout. But it is a very complex process. There's a lot of attention to detail with certain forms, timelines, procedure, that kind of thing. So it's always helpful to have a professional service like ourselves, either a registered unlawful detainer assistant or an eviction attorney, to be able to handle that process for you and take some, load off of you as a landlord, because you're already facing a troubling time where, tenancy has been terminated and you need to move forward with an eviction. So the less stress, the better. We do keep you informed of the process as the case progresses. And if you have any questions, we always make sure that we address those moving forward, so on and so forth. So anyway, thank you for tuning in, and I look forward to working with you.